I just melted some plastic on it.
Good evening, everyone. Can you see me? Hello, everybody.
Yep, can see you.
Can you see? So I've got Courtney there, Miranda, Daryl, Jade, and Cindy. Anybody else?
Yeah, and Michael.
And Michael. You're there somewhere. Oh, yeah, Michael there. That's right. Okay. Good evening, everyone. So just double checking. You can all see me and hear me?
Yes.
That's good. Okay. Now, welcome to the week 2 session. This time I made sure that we're recording it properly. So what we're doing is tonight is talking about a formation of a contract. Sorry, someone's talking in the background. Maybe, or maybe someone elsewhere, but perhaps you could not talk. Now, we're talking about a formation of a contract, and I've got some notes here, and it said, look, a contract is a type of promise that the courts will enforce. And we all know that, you know, you go down and buy a pizza, you buy a drink, you buy a car, buy a house and stuff like that. That's the way it works. But there are some which are enforceable and some which are not. Can anyone remember from last week which ones tend not to be enforceable?
Family arrangements.
Yeah, exactly, family arrangements. And they're the ones, like I gave the example, like little kid comes up and says, look, I want to go to the movies, and you say, look, if you clean your bedroom up, I'll take you, and you don't. Can the kids sue you? And no, they can't, because there was never an intention to be legally bound. So a contract is a type of promise that the courts will enforce. So remember last week, or I'll just continue here for those who weren't here. Look, a contract is an exchange of promises. I promise to mow the lawn for you, you promise to pay me. Okay. Now, how is that different from the little boy who says, I promise to clean my room up if you promise to take me to the movies? Okay. So I think that the main difference there is the intention to be legally bound. And if there's an intention to be legally bound, well, therefore, the courts will enforce it. Now, I see some of your microphones are muted. Unmute. There we are. So, Jade, can you hear me?
I can hear you.
Good. Courtney, I've unmuted you. I'm getting used to, I've never used this package before until last week, so I'm just getting used to it. Cindy, you can hear me?
Yep.
Good. Miranda, you can hear me? Michael?
Yeah, I can hear you.
Is there anyone else there? Okay, so let's get stuck into it. Look, contracts are just about promises. As I said, a very simple promise. I'll cut your lawn, you give me some money. That's it. Now, the big question is which ones will be enforceable, which ones are not. Now, the ones which are not enforceable, well, there's no contract there, so the law of contract doesn't relate. So really, the big issue is, when do we have a contract? And depending on which textbook you look at, there's a number of different ways of looking at it. And today is the first one we'll look at, is capacity, and whether a person has the capacity to enter into a contract or not. Now that's the first question. The next one we'll be looking at next week is intention of the parties. So that's a little bit more of what we've just been talking about a few minutes ago, whether the parties intended to. And the one after that will be agreement. An agreement is an offer and acceptance. And that's a really, really big issue, is one party has to make an offer and the other party has to accept. Now, I see Jade is muted again. I've unmuted you, Jade. And Cindy, I'm unmuting you again. And Michael, I'm unmuting you. Now, I don't know why you're muting. Michael, one unmute. Oh, there, I've got you there now.
Yeah, I've just got it muted unless I'm going to talk, so background noise doesn't come through.
Oh, yes, okay, that's okay.
So I can hear about 10
keep
background
in
noise.
the background every time. Okay, so So the first, today's capacity, intention between the parties. Another one's agreement. Agreement is known as offer and acceptance. And then we have a thing called consideration. And in English law, we have to have something going in each direction. Okay? Can you see me? Is that a yes or no? Can you see me?
Correct.
Yes, you can see me. Yes?
Yes.
Yes. Okay. So something must go in each direction. And you remember last week, I actually had a drawing for you. In that drawing, I showed you there was two parties, the buyer and the seller. And what does the buyer do? It gets the goods and services, and it has to pay for them. And there's rights and obligations on both sides. So it's got to be something going in each direction. The last one, which we'll do, will be the certainty and completeness. You've got to be certain. I mean, you can't have a contract where people haven't even discussed the money yet, or what work needs to be done. So it needs to be pretty tight. Okay. So they're the sort of things we'll be talking about. Just while I'm here, just the assessment. You will have a quiz for 5 marks, which will be ready for you from the 1st of December. I've got the boss to help me today, so we've got all that organised. It's on the computer under assessment, and it's a short one. There's just 10 questions, half a mark each, and you give oodles of time. You give them 2 hours to do it. Okay, so oodles of time, and you have all of the first, second, third, I think part of the fourth. So there's quite some days that you can attend to the assessment. The big assessment we're working on at the moment. Okay, so that's what's happening with that. Okay, so let's get stuck into it. So today is really about who has the capacity, and that's actually really quite important, because will everyone be bound by their contracts? Now, what happens if you're playing football and you get a concussion, and you're really not sure about things, or you've had too much to drink, or you've popped some pills, or indeed that you're schizophrenic and you enter into a contract? Okay? So they're the unfortunate things which can happen. Now, the law sees that and wants to protect the vulnerable, but needs to strike a balance between those who are vulnerable and those who try to take advantage of them, and then the honest person who deals with someone who's vulnerable. So if you've been doing your reading, there was half a dozen or so cases, and you'll see how they go. Now, I think I may have given you this case last week, but I'll just give it to you again very shortly. A client of mine was in business, and the client happened to be addicted to cocaine. And so the client had on certain times was very astute, and other times wasn't. So it was up and down mentally, and you never knew where the person was. And I got a phone call stating that they'd bought. Did I tell you the story last time?
Yes.
Yes. Well, just for those who are new, in essence, bought a whole lot of jewelry, $30,000 jewelry, and then rang me up and said, look, I don't feel that I was in a fit state when I purchased it. I went to the jeweler, and the jeweler said that as far as the jeweler was concerned, the client was perfectly able to make decisions, and would see no reason why the contract should be avoided at all. Okay? So from what you for the viewers there, from what you've read and done your homework, do you think that this lady could get the $30,000 back again? Do you think? Was there a situation? I will unmute Jane, unless you want to stay muted. Courtney will unmute you. Hello, Vikram. Do you think that this person would be able to avoid the contract? What do you think? Anyone?
Would the incapacity mean that she couldn't understand the nature of the contract? I think that would be the main point, wouldn't it?
Yeah, well, that's what she's alleging, that she didn't understand the nature. And as you know from your notes, it's got to be that basically she understood the whole of the contract. Now, I wasn't there. I don't know. And the other part is whether the vendor actually could see there was a problem. So I said to the vendor, look, she was not fit at the time, and the vendor cut me off and said basically, look, all my staff will attest to her being of good, sound mind. In fact, she was quite cheery. We made her a cup of tea. We had a good old chat. And then she went across the road to the bank, come back with a $30,000 bank check, and took the goods. And my staff will attest that she was perfectly sane at the time. And by the way, if there's a court case, we will subpoena the bank teller and ask the bank teller what the bank teller thought of this person. Do you think the bank will allow a bank teller to say, she was nuts at the time? Of course not. So I went back to her and I said, listen, baby, just forget it, because you're going to spend megabucks on a legal case, and it's not particularly strong,
Wouldn't it also come back to the fact that she's on a drug that she's normally on where she performs well?
Sparrow, no.
So I didn't catch that. Can you say that again?
So she's a habitual user of cocaine,
yeah,
and performs with it normally, and now she's using as a defence that she's using cocaine and wasn't clear-minded at the same time.
Yeah, but the fact is that she's stating that her mind was clouded.
Yeah, but at other times it's crystal clear, and she performs better on it. So
yeah,
it's a positive sort of response.
Yeah, but see, and this is a good lead into what we're discussing today. If you've been reading your notes, and we'll go through it logically, but just on this topic, if you've been reading your notes, you'll recall that someone could be blind drunk, but they still could understand a simple contract like, hey, cabbie, I live in XYZ, take me home, in comparison to quite a complicated contract, So there's degrees of not being able to comprehend what's going on. Okay, so I thought the best thing is what we do is we just quickly go through the law, just make sure we got that under our belts, and then we'll go through the questions. Actually, quite an interesting question. And there's two people, actually three. In fact, when you think about it, there's 4 people in that question. Okay, so I'll just get my notes here. Now, for some reason, Jade has been unmute you. Courtney, I'll unmute you if you want to say something. And I think Michael, you had kids in the background, didn't you?
No, it's not me. It's just I can hear everyone else's background.
Oh, someone said. All right. Look, and Miranda, I'll unmute you. And if you want to become muted again, just send me a text there on the screen there. Okay, so I've just got a couple of notes here as to who may enter into a contract. Look, obviously, not everyone has the capacity. And let's think about it logically. You could be infirm, aged, 95 years of age, and someone comes and puts a piece of paper under your nose and you sign it. You don't know what you're signing. That sort of thing. Another one is, as we said, a person of under the age of 18. 30, 40 years ago, it used to be under the age of 21, but it's under the age of 18. So not everyone has the capacity to enter into a contract, and there are certain vulnerable categories of persons, and the law tries to help out these ones. And the categories which we're going to talk about tonight are minors, and we'll see that come up in our tutorial question. Those who have temporary mental incapacity, again, we'll see that coming up in the tutorial question. And those who are intoxicated through alcohol, drugs, etc. So they're the important areas we're going to be looking at. Now, can someone tell me what the general rule is?
With minors,
yeah,
they can be voidable, and they have to ratify or they have to repudiate.
Yeah. And when can a minor be held liable to the contract?
For necessaries.
For necessaries.
That's the first part, and the second part?
For education or for work.
Yeah, education and work. And it makes a lot of sense because there are certain things. Now, unfortunately, with the law, it's never clear cut. There's, is this necessary or not? And that's been picked up in our tutorial question because to get us thinking about that sort of stuff. Okay. So with mental disability, as we said before, they're treated the same way as under the contract law, whether it's a mental disability or intoxication. Now, the High Court, in the case of Gibbons and Wright in 1954. Now, this is important because when we get a High Court decision, it's a really important decision. If you have a state court, well, that's okay, single judge. If you have an appeal court, that's stronger because there's usually 3 judges there. And the higher up the ladder you go, the better it is. And you all would have by now have studied a subject, basically introducing you to the law. So Gibbons and Wright looked at the law in the UK, and basically it said, ask if the person making the contract was capable of understanding the nature of the contract. Okay? So it's just, were they capable of understanding? Okay? And that's the first half of it. And I mentioned to you before, the drunk. Drunk may be able to understand a simple contract like "get me home, please," but not something like quite a complicated financial document. And we mentioned that before. And the other half of it is if a person is not capable of understanding the nature of the contract, you must ask whether the other party was aware of the condition of the drunk or drugged person. And so I wasn't there at the time when this client bought the jewellery, so I don't know whether the person was incapable of understanding, but from the facts, and that's what the court would look at, from the facts, it looked like the vendor, supplier of the jewellery, wasn't aware of any incapacity at all. And so in that case, it'd be very hard for my client to do anything about it. So what I thought we'll do now is let's have a look at the tutorial question. Now, what I normally do is I think it's very important to understand what the facts are. So be really, really clear as to what the facts are. You're not doing examinations, you're doing more essays and things like that. But particularly in examinations, when you do them, you don't have much time, you're under pressure, you're stressed and things like that. Be really, really careful. I used to say to everyone, in fact, I did it myself, read the paper 3 times. First time you read it, just don't have a biro in your hand, just read it. Second time you read it, underline keywords. And the third time you read it is make some copious notes as to what's happening and where you're going to write it. And be very, very clear about the facts. It's absolute a crime to fail or do badly on a question because you haven't read the facts right. Now, ordinarily in a law exam question, every single sentence will have something of relevance in it. That's the reason why the sentence is there. I mean, you have a blank piece of paper, the person who's writing the question writes it for a reason and puts facts in for a reason. So you look around and you'll see there's bits and pieces stuck in there everywhere, and you need to think those things through. So be quite aware of the facts. Apply the law to the facts, and then just come up with a suggested answer. Now, if I was marking it and someone got the wrong answer, but they used the right legal reasoning, well, you get plenty of marks for that. I wouldn't give you too many marks if you guessed an answer, but if your legal reasoning was good and maybe you took the left-hand turn when you should have taken the right-hand turn, you can be forgiven for that, but you still get some reasonable marks out of it. Okay? So there are 4 people in this tutorial question. The first one is Glenys, and she's the owner of the store. Okay, so she's a salesperson and the owner of the store. Now, I don't know how to pronounce this. Can you help me? How do you pronounce this girl's name? Namaya? How do you pronounce it?
Naeem.
Niam. Niam.
Your silent H.
Niam. Oh, good. Thanks very much. Niam. So Niam is 17 years of age. And so what I've done is I've just done a quick digest of the facts. She's 17 years of age. She's still at school. She goes and buys a dress. And the dress is for a function, a formal function. It's interesting. She pays fully cash for it, and for the dress and the alterations. Later on, her mum comes in and demands a refund and basically a repudiation of the contract, saying that she's acting on behalf of her daughter. And she says, well, she wants a refund because the daughter's entitled to it, because the daughter is a minor. Okay, so they're the facts in relation to Niam. So Jenny, she's older. She's in her mid-20s. She's a competitive ballroom dancer. She tells the owner of the store, Glenys, that she needs a new dress for her competitions, and she buys a $2,000 dress, which must be ordered from the United States. Now, what the Glenys does, the owner of the store, she takes a $200 deposit, and 2 weeks later, owner of the store gets a phone call, and from Jenny, stating that she was suffering from depression at the time when she went into the contract, mainly because she didn't take her medication, and she doesn't want to go ahead with the contract, and basically she doesn't want to pay the other $1,800. Now, Glenys was pretty unhappy because she's paid the supplier for the dress. Now, just as an aside, if you are running a shop, would you pay for the dress in advance if you haven't been paid by the customer? Question mark.
You'd want a bigger deposit.
Yeah, there's no right or wrong answer in that. Sometimes you have to order well in advance, and you can't order unless you pay the whole amount. Or maybe you know Jenny, she's been there a dozen times before. But just from a commercial viewpoint, and I deal a lot with small business, etc., I wouldn't advise that. I should cover her bottom. Even if she's buying it for $1,200 and she's putting $800 on top of it, I'd at least want $1,200 from the customer. Okay? So Glenys is unhappy because she's paid for that, and so basically we're sitting in her office minding her own business. Glenys makes an appointment, and she wants to know, how do we deal with each of these 2 customers? And that's what we're going to do now. So let's have a look now. Would someone like to start off with the first one, the young lady who's coming in to buy her school social dress? Would someone like to help me out there? Just start. Look, give it a go. Whether you're right or wrong, it doesn't matter. The fact is, you give it a go, and when you talk it through, sometimes it's easier to remember. Who would like to have a go?
Yeah, I'm happy to do this.
Yeah, give it a go.
Well, who's going, Courtney? Or?
Oh, you go.
All right.
Do a little bit, and then Courtney can take over. Okay.
Okay, I've done the ORAT process on this. So I've said, is the contract between Glenys and Niam valid, even though Niam's a minor? I've got it as a rules. Is the contract for necessaries? Is it a beneficial contract of service? And I've got a third point on here, which I want to clarify with you, is if the minor pays for it in cash, in full in cash, I've got it in another law textbook that I've got that says if a minor pays in cash in full, that it's valid contract. If that makes sense.
Actually, it doesn't. But let's take these things now. Courtney, did you want to add anything to that?
No, it's all good.
Okay. So look, the general.
I'll actually ask a question while we're here as well.
Yeah.
So I was reading through, I think it was chapter 12 or whatever. I think I found somewhere that said that the mother can't actually butt in on that contract because the contract's made between the minor and the store owner. So is it not between them two to decide whether or not to proceed with the contract because she's paid up front already?
Mum's a legal guardian, so she can interrupt.
Yeah, is that right, Bas? I swear I read it somewhere in that week's reading, but I just sort of can't remember where I found it.
So the question which we've got in front of us at the moment is what rights does the mother have in order to affect the contract, to speak on behalf of her daughter? That's the question, okay? So who would like to have a chat about that? What have you been reading?
My computer dropped out. It decided to restart itself. I missed a little bit.
So the question is that Naeem, she went into the contract, and the mother now is butting in. The question is, can the mother butt in and say to the daughter, "I don't want you to buy that dress," and say to the vendor, "Not over my dead body is she buying that dress." Okay, so she's coming in as a parent or as a guardian.
So I looked at that she'd already paid for the dress and paid for the alterations. So there wasn't a dispute about the money. It was a dispute about the dress. So maybe there'd be an arrangement between them to look for another dress for the same amount.
Yeah, well, that's a compromise. Yeah. What? Go on.
Well, the
But
mother's
the thing is, I was being the parent and the other girl being the minor, they would obviously hold sway over what goes on, but I wasn't too sure about whether they'd get the money back or not.
Well, the mother's obviously given the daughter $1,200 or however much she had in her pocket to go shopping to find a dress. And it's the fact that the mum's just not happy with the dress she selected, not the fact that she needed a dress and gave the daughter
You
the
don't
money.
know that for fact there, Michael. You only are assuming that the mother gave her the money for that dress.
Yeah, that's fine. I can assume that. But I can also assume the fact that she had the money and that's just walk around cash money for her too. That it's not something that she's had to borrow money or she's stolen from her mum's wallet. Mum's come out and clearly stated that she's just not happy with that dress, not the fact that she bought a dress.
Well, what's the general rule? The general rule is that contracts with minors are voidable, okay? And then the next part is that unless it's necessary, and we've got necessaries under both the common law, which is basically the judge-made law, which we've been talking about. Don't forget the statute in Queensland, which doesn't really say much more, except it talks about it has to be a reasonable price. Now, that issue of reasonable price has never been discussed at all, was never mentioned at all. So now we're going to talk about what was it a necessary or not. And so the first issue is would a dress like that be a necessary for that particular person? What do you think?
Up and coming event, yes.
She obviously needs something for the formal, but we don't know what the dress looked like. That's the trouble.
I think
Could have been a skimpy thing. I don't know.
Half the kids wear skimpy things. I think that's...
If she would have gone into a contract with a telco for a phone, is that a necessary? What happens if it's an El Cheapo phone versus the very most expensive one? Is it a necessary? And this is where the law, where it's difficult. Some cases are pretty obvious, and other cases are less obvious. And it's often the less obvious ones which go to court. Why would that be the case?
That's where your disputes arise from.
If it's pretty clear, generally speaking, they don't go unless someone's a little bit wound up about it, or to the lawyer's delight, someone comes in and says, it's the principle of the matter. Because as soon as they hear that, they think, oh, well, there's like the second car, and there's a new kitchen there and stuff like that, you know. So you've got to be a little bit careful about this. So what did we say before? It was the necessaries. goods and services are necessary if they are appropriate to the miner's station in life and they do not have an adequate supply. Okay, so I don't think the adequate supply, and there was a case on that, station in life. So you might say that it's important for the peer group that she goes to this social, and as long as it's reasonably decent, the clothes will be acceptable. The mum might have a different way of seeing things. So now we're not talking about employment or education. So that second part is not so relevant here. It's really to do with the necessaries, which is the important part. You have to ask more questions. See, if you were handling this file, you're going to ask more questions, and depending on who you're representing. Now, of course, there's not much money in a file like this because how much can they pay? If it was a big corporate case where there's lots of zeros on the end, well, you can spend the time and go and look it up. But we're here to talk about the law, not so much about the practice and procedure. But ultimately, that always needs to be considered, the practice and procedure of the law. But you really need to find out more about this young lady, how she fits in her social group, and whether it is a necessary, and the definition of necessary, are they appropriate to the miner's station in life? And that's what she's doing there. So if there's a closely knit group and she'll feel bad about being in the group, and not being in the group or not being there, or wearing something which is not so attractive, it might be necessary for her. Now, what's the law if it's found to be necessary?
Then it's a contract is upheld, ratified.
Yeah, it's upheld. You know? And now what the mother is now saying, well, hang on. She's saying, hang on, vendor, you're not going to be able to keep this because she's a minor. Okay, so. So she's a minor. Now, I just got myself, I wrote a few notes to myself here. Look, I'll just go through them in order, just so I make sure I haven't forgotten anything. The general rule is that contracts with minors are voidable, not voidable if it's necessary. And remember, necessaries can be at common law and statute. Now, some of you may not be in Queensland, and therefore you'll have other statutes. You'll have your state ones, Victoria, New South Wales, etc. And you always got to check them out. So in answering this question, there will be a dual layer of law. There'll be the common law, the default law in the background, and there'll be statute. And I've got a note here to myself, if not necessary, she can avoid, that is, repudiate and get her money back. Or can she repudiate and get her money back? To get her money back, you need to have a total failure of consideration. Okay, so yes, she may be able to avoid the contract, but what's happened already, she's been given the dress, in other words, the dress itself, and indeed the dress has been customized for her. And so I don't think there's been a total failure of consideration, because if you read your notes, they talk about that. So as she's got the goods and they've been customized, I don't think she can get the money back. And so if we were advising the owner of the business, we'll say, well, she does have, the young lady does have the right to avoid the contract, that it's avoidable at her option. She can repudiate if she wishes, because she hasn't passed the age of 18 yet, so that's not an issue. So she's under the age of 18, but she can repudiate as she wishes. And ordinarily, had she not got the goods, she'd be able to get the money back. But I think because she has had the goods, because there has not been a total failure of consideration, she will not get a refund. So that's what I think the answer to the question is. Any comments on that? And so what you've got to do is you just got to follow step by step by step. And someone mentioned before the IRAN, I-R-A-N, the method, which is not dissimilar to mine. I just keep it simple. You know, it's the facts, the law, apply the law to the facts and come up with a conclusion, which basically is the same thing. But for heaven's sake, know your facts. And particularly on a large assignment, if you don't look at the facts and all of the facts. Now, people who write questions love making it complicated. They want to see what you know and what you don't know, and they'll sit there for ages and they'll put this one in and say, what if it had been like this? Or put in something like, well, she came back, she rang back 2 weeks later. Now, does that not, what does that tell you? This is the next girl. This is, what's her name? Jenny, isn't it?
Jenny.
What is the significance of ringing up 2 weeks later? And if I had a chocolate here, I'll give it to the first person who answers.
It's a long time.
Huh?
It's a long time, 2 weeks.
Yeah. And what is the legal ramifications of a long time?
Hang on there. I've written it down in my answer. I've got to find it.
She's basically ratified it.
Yeah.
Good stuff. You get the chocolate, man.
Who? Do we share it?
White or dark chocolate, okay? All right, so let's go back. I've got, see, now the point I'm trying to make, I'm not trying to trick you or anything like that. What I'm trying to say to you, that you sit here and it's midnight and you're writing a stupid question and you think to yourself, I've got to make this interesting. I've got to see how good they are. So you slip something like in, she rang back later on. Now, if there's nothing there, what would a good student say?
How long?
How long? Perfect. And then you'd say, had it been shortly afterwards, and you'd say there's there is no ratification, and you'd say something to the effect that she repudiated it, and there could not be a ratification because it was shortly afterwards, if not straight away afterwards. However, you'd say because there was 2 weeks, or you'd say if there was longer time, for example, 2 weeks, there is quite a possibility that it will be seen to be ratified. Okay. Now, where the difficulty arises is she's sick one day, then later on she comes to, and then she waits a week. Is that too long? Or she comes to in the morning, she wakes up, she feels good that day. Should she go back that day? I mean, that's the ideal situation. What I'm trying to say to you, that where the difficulty in the real world arises, is what is a reasonable period to ratify or to repudiate. Okay, repudiation is when they want to get out of it, they need to do that pretty quickly, and that's where you get the disputes, and that's where you get the court cases. Unless someone's got a bee in their bonnet and who's willing to pay lots of bucks to get a principal, and I love those people because they're the ones who pay your bills. You know? Okay, so let's not be cynical. Let's go back. So I'll take it step by step. So this is the second question. I've given you the facts already. The area is mental disability. Now, what does that tell us? It tells us we have to go to which case? The one up here. The Gibbons and Wright one. Now, when you're writing a question, if you can't remember the name of the case, you say it's the question mark versus question mark High Court case where they said where they followed the two rules from the UK. Okay. Now, I suppose all of you would have done something to do with Introduction to Law, how you use these cases, but that's the way you would do it. Now, that's more of an examination situation. When you're doing an essay, an assignment, you'll have plenty of time. You'll be able to look it up. You go to your textbooks. But I'm just saying that it's not the name of the case. It's the principle in the case what we're looking for. I mean, having the name of the case is great because then you can identify it. So according to the Gibbons and Wright, the 1954 High Court case, we have two key rules that apply to persons who are under a mental disability, which is drugs, alcohol, etc. And Jenny, she contends that she was under a disability at the time because she wasn't thinking straight because she didn't take her required medicine. Okay. So the rules are basically incapable of understanding, and not aware. So the facts here: was she capable of understanding? Was she in depression? We go back to that quite a good analogy which I got from the book about the taxi driver, the contract with the drunk and the taxi driver, and a very, very complicated financial contract. Was she so much affected by the by not taking her medicine that she couldn't comprehend a simple buy-sell agreement? Because, and you could quite argue that I'm wrong and say, for a person who's mega depressed or under having mental difficulties, just going into a shop and buying some clothes and fitting them and stuff like that is a big deal. And I could argue back, well, depending on the person, all she did is went to the shop and said, look, I like that one, let me try a couple on. Oh yeah, that's the best one. Here's $200 and I'll pay the $1,800 later on. So we don't really know from the facts how depressed she was. And that was the first one. Was she incapable of understanding? Now, you need that. It's a prerequisite. And then you go to the next one. If the person is not capable of understanding the nature of the contract, we must ask whether the other party was aware of the condition of the mentally disabled person. Now, there are no facts to show that the owner of the shop was aware. But having dealt with people like this in the past, sometimes they look as if they are quite lucid, but in the back of their mind. And indeed, that client, the one I gave you before, I wasn't there at the time, I can't tell whether she was in a lucid period or not, but when she's snorting the stuff and she's having a bad day, she's having a bad day. So we don't know that sort of stuff. And I've got a note to myself, just for discussion here, that a party who contracts in good faith with no awareness of the condition of the other person will be able to rely on the contract. And it looks more and more like the owner of the shop has contracted in good faith, wasn't aware of the problem. I've got here, if Jenny, who's the customer, can prove that she was incapable of understanding, and the vendor was unaware. So, but when the vendor was aware of her circumstances, then the contract would be avoidable at the option of the disabled person, where she would do the usual sort of thing, either ratify or repudiate. Okay. Then I made a note to myself. And I've got to say to you, it was only after I looked at it a couple of times and I realised, I bet that the examiner has slipped this one in, the 2-week business. Okay? So ratification, tell me when does ratification begin?
When they reach 18 years of age, we're approaching it.
That's if they're a minor. Now, we know from the facts that Jenny is in her 20s. Okay?
Oh.
She's a mentally disabled person. So that's the other category of person. So when does the necessity, when does the point start where she has to decide to ratify or repudiate?
When she comes out of her mental state.
Good stuff. Now, that's a question of fact for the court. Now, she can say, oh, look, I was off the planet for 2 months, but she didn't take 2 aspirin, okay? So there's a bit of credibility involved. Now, normally this wouldn't go to really in-depth hearing, but we're talking about a few zeros on the end. This is where you'd get psychiatrists and expert evidence to come in, and the court is not medically trained. The judge is not medically trained and wants to know the facts generally in the population and how it applied to this particular person, and therefore you need an expert evidence. In a past life, I was an expert in a number of cases. Actually very interesting. I'll talk to you about that another time. So the issue of 2 weeks, maybe, I think it was Jason who said it when she came out of it, maybe she came out of it, but by not popping it, well, maybe by not taking your tablets, she was off the planet for 2 weeks. Maybe then she started taking her tablets again. So we don't know. And therefore you have to argue in the alternative, and you have to say, well, if it's this is the situation. But if it's this, that will be the situation. And that's where you get your marks. whether it's an examination, in an oral a presentation, or whether in an assignment, arguing the alternative. And therefore, I go back to what I said before. You really need to sit down and look very closely at the facts, understand the facts really well. And I'll be honest with you, it was at 1 or 2 readings, and then I saw that 2-week business. I thought, oh, that's a sneaky one there, and you have to think that through. Okay, so let me go to the next one. I've just got a note here. I feel that Jenny needs to pay the balance under contract law, because the 2 key Gibbons and Wright High Court factors are not present. And if they were, arguing the alternative, if they were, she did not immediately ratify. But thinking about it now, I need to write more on that, because maybe she was in a coma. When I say in a coma, she was, like a walking dead person, like a zombie, for 2 weeks beforehand. Maybe she just came out of it the day before. We don't know that. But I reckon it's looking good. I can't guarantee it, but it's looking good for the vendor for the $1,800. Now that also raises the question: is would anyone bother to sue for $1,800? Where I come from in the corporate sort of world, to shake hands with a lawyer cost you $2,000. And then you cry in a cup of tea, it costs you another $2,000 to do that, And after a couple of days, there's $100,000 on the clock. Okay, so you need to look at this from an economic viewpoint, but we're not here to talk about that, so I'm going to avoid that. But I do feel it's my duty just to when we talk about contracts, contracts are the glue, or a contract is the glue that sticks commerce together. If we didn't have commerce, if we didn't have contracts, commerce would be a mess, because people would say, "Oh, I'm not honouring that contract." I was going to buy that building, or I was going to buy this crane, or I was going to dig this hole. I don't want to do it. It's not in my interest to do it. You can't do that. Once you have decided on a set of promises, and once they've been formalised into a contract, you're bound. And that goes back to that classical theory and the promise theory we spoke about last week, and which was also the part of that was the obligations theory, the obligations of the parties. Okay, so I wasn't going to really say much more than that. It gets us going. Now, next week, I've got here a summary from the lecture, and I think it was the very last slide, and I just thought I'd read it out to you. And in fact, it's really quite straightforward. We've done it a couple of times already, but just for the sake of completeness. In topic 2, we learned minors have a limited capacity to enter into contracts. Oh yeah, and this reminds me, I know that some of you weren't here last week. My mentor, he came home one night, and he was my contract law mentor. He was an English barrister, a retired English barrister. And his daughter had all these cosmetics across the table. And he said to her, "Darling, what's all this stuff here?" And she said to him, Daddy, I've been reading your contract law books. I don't have to return these. And he said to her 2 things. The first thing he said, "I'm so pleased that you'll be able to understand this is quite a complicated part of the law." And the second thing he said, "Get that stuff out of here, back to the vendor." So what he was talking about, there's a difference between law and ethics. That's something to talk about another day, but we're talking about the law here. So certainly, the young lady who got all these cosmetics, does she need to return those? I think she can just repudiate. Be difficult for the vendor to get them back again. So. Hang on. So here, capacity contract review. Minors have a limited capacity to enter the contracts. Contracts for necessities are binding on all parties, and you've got to show whether it's a necessity. So what may have been a necessity quite some time ago may not be now, and vice versa. Goods and services necessities if they are appropriate to the minor's station in life and they do not have an adequate supply. A beneficial contract of employment or education is binding on all the parties. Any other contract with a minor is voidable. Contracts with intoxicated or mentally unwell people are voidable, and the defendant was unable to understand the nature of the contract and if the other party knows of the condition. Voidable contracts can be ratified or repudiated. Okay, so that's really what I wanted to talk about this here. And next week, we're going to be talking about intention. And as we started off this evening, we spoke about intention, like the little boy in the room who wants to go to the cinema and has done his part, but the parent hasn't done their part. Do they intend to be legally bound? So often, family-type agreements, there will be no intention to be legally bound. But let's take some famous people in Australia. What about the Packers? Let's say James Packer and the late Kerry Packer. If they went into a business deal and one reneged, could they sue on those? Well, before you answer, what about Gina Rinehart and her argument with the children about the trust funds? We're talking about a couple of $1 billion there.
Well, that went to court.
It definitely went to court.
Yeah, she lost.
Yeah, well, there have been a number of cases there. Let's take James Packer goes into a deal with his dad, I don't know, to buy some shares in one of these corporations. You know, we talk $10 million. You know, do you think that the court will enforce that?
That's legal intent.
And why do you say that?
Well, it's a business. It's like someone taking their car to get serviced by their son at their mechanic shop. It's a business transaction, not a social engagement.
Well done. That's good. That's the way it is, you know. And sometimes this gets a little bit close. And the example we had last week was we spoke about that newspaper situation there, which you'll come across again. Simpkinson Pays is the case. But the key issue there is trying to separate them. Now, what you can do, and which we'll see, you can actually, in the document itself, you can actually say, if it's a social and domestic agreement, you actually want to be legally bound. So you actually write it in the document. Likewise, if you have a commercial deal and you don't want it to be legally binding, because basically commercial dealings, the parties work on the understanding that if something goes wrong, you're going to go to court. What you do is you say, we don't want to be legally binding. So if I go to McDonald's, I can certainly tell you 110%, if I eat something and I get sick, I'm going to sue them. And likewise, if I go to the dentist and I get an infection, or if the plumber comes to my house and burns the house down because they left something on, or his flamethrower, caught the curtains, I'm going to sue them. Just by the way, just reminded me when I was talking to you, those of you who've been to the UK, you've probably been to Windsor Castle. It burnt down 20 years ago, 1990, okay? Oh, a bit longer, isn't it? Yeah. Why did it burn down? What caused the fire?
Wasn't it one of the staff members?
I'm sorry, what was that?
Wasn't it one of the staff members?
Yeah. Now, what happened is actually, my recollection, I might be wrong on this, they had some tradies there, and they're putting up some spotlights. And they put one spotlight too close to the curtains, and the curtain caught fire. And because it's a very old building with the timbers dried out over the last 1,000 years, it just went up in flames. Now, of course, it's sad to see a historical building like that go up, but that is, and later on in your legal career, you'll be talking about negligence, a duty of breach of duty of care. But while we're on contracts, it's a breach of contract. I asked you to install the lamps. I didn't ask you to burn the place down. You breached it. And there's an implied term is to what you're going to do is going to not cause any damage, all of which we'll be talking about later on. Now, mid-semester, we'll be talking about, midterm, we'll have a skills week. And the week after that is where we talk about terms. Terms are the promises. And you have express terms. When I sell you a dress, that will be $2,000. I'll take $200 now. I have to order it from the States. It'll be here in 4 weeks. That's an express term. An implied term, which is never ever so stated unless it's been requested expressly, is that it will be made with it'll be properly made. It's not going to fall apart. It's going to be fit for purpose. All of those. Not only do we have that in the default law, we have that in our legislation. We have the Goods Act, or in varieties all around the country. So these are all the things that we've got to think about. Okay. So look, are there any other questions you'd like to discuss at all? Anything you'd like to talk about?
Those honour clauses, are they prevalent all that often or not?
When you say honour clause, what do you mean by
The
that?
ones where you're not going to, you're going to write up, you go to the effort of writing up a contract, but you're going to infer that you're not going to sue each other if something goes wrong.
Well, that's a very good question. That goes to the branch of, first of all, we're talking about contracts, and the second, we're talking about a creation of a contract or non-creation of a contract. What we, on the general rule with commercial contracts are the parties want to be legally bound. Therefore, if you want to do the opposite, not be legally bound, you have to write something there. So as long as the contract was written without any force, duly authorised by representatives of both corporation or the individuals, I'd have to say, in my opinion, it would not be binding.
Can't remove statutory laws.
Sorry?
Can't remove statutory laws.
But this is not a statutory law, this is common law.
Yeah, well, you can't take away legal rights from someone in a contract.
But we're agreeing not to we're agreeing that there will not be an intention to sue.
Or intention to sue or not to sue.
Yeah, and that's a case like the Rose Frank Compton is your case in that. My recollection of the case is that there was an American company, an English company, and they signed a document stating that this is an agreement in honour only. However, the parties will not sue each other. And that the American company wanted to sue, and the British company said, look, there it was, there's the contract, and the court agreed, and it said that you can decide to go contrary to the usual situation. The usual situation with a commercial contract is that parties want to be bound, and if you want to go contrary to that, well, see, remember, a contract is an agreement between two or more parties that the courts will enforce. You know? And likewise, if it's a social domestic and you do want to make it legally binding, you can write that in your contract. Now, I don't want to make it too complicated here, but have you heard of MOAs and MOUs? Memorandum of Agreement and Memorandum of Understanding? Well, they are just usually just quick documents, a page or two, and they're usually originally from government. When my government department allows a couple of rooms at the back for the local church tennis club or something like that, you can give them for a few bucks, or we got some employee who's seconded somewhere else. And it was originally like that. Now they're being used in commerce to the horror of many lawyers, or the other way around, to the great glee of many lawyers, because there's so many cases coming out of it. See, what normally happens, people think that these MOUs and MOAs are legally binding, or the other way around. The best way to do it is to ensure you have all the prerequisites of a contract. And what you'll be learning this semester, it'll be this you need. As long as you have all of those, and the clear intention of the parties, you're right. So you create a contract and you make it even more firm, clear. You might have clause number 1. The parties intend to be legally bound. Or clause number 1, the parties do not intend to be legally bound. And that's a far clearer situation for it. Because you don't want a situation where you have an MOU, which is just basically one piece of paper where the parties speak using motherhood terms, and then you're not quite sure whether it's binding or not. and you need the court. And the court will go through it and will have a look at the hallmarks of the contract. Are they there? And I tick them off one after the other. I remember reading a case a number of years ago, and there was a situation like that in New South Wales. I just have to remember it. And the judge went through and said, yeah, that looks like they intended to be legally bound, and this doesn't look like it, you know. So why cause all that problem and redistribute wealth towards lawyers? Why not just put in clause number 1, we intend to be legally bound. The parties intend this contract to be legally binding, this agreement to be legally binding, or the opposite. Okay? So make it crystal clear, and that's how you can avoid legal problems and lots of time and money lost. Has anyone ever been in a court case?
Going through one now.
Yeah. Okay. Don't tell us too much about it. What's basically this is all about?
I bought a brand new 2015 wake boat, and I got delivered a 2014 used one.
Oh, you mentioned it last week. Yeah. Well, see, what you do is you would say, there's a lot of law here. We're dealing with contracts. Therefore, my contract was with a 2015 boat. You breached it by giving me a 2014 boat.
Yeah.
Number 1. Number 2, under the legislation, which is the Goods Act and all that sort of stuff like that, you didn't give me what I asked for. The sample you showed me was a 15, but you gave me a 14. Then you go to misleading, deceptive conduct. I asked for a 15, and you gave me a 14. You deceived me. Okay.
Yes.
And then you'd go the state equivalents of the Fair Trading Acts and stuff like that. So you've got a lot going for you. However, you and I both know the documentation is just horrendous. The time involved with all of this is, and what happens in some of these businesses, they stretch it out as much as they can, so you get totally sick of it. Okay?
Yes.
And the point I was trying to make, I don't want to lose the point. The point I'm trying to make is these court cases and disputes are extremely time consuming, and you've got to have your facts, and it's very easy to make a mistake, and you don't know what emails your employees have sent, or what you sent before and you've forgotten, and all these sort of things. So it could go either way. So there's always a bit of risk in all of this. So be aware of the facts and know your law well. Okay. So I suppose anything else you want to talk about?
No, not at this stage.
So what we'll do is just remind you next week will be about intention, and we will follow from there. So just do the questions, and I've got to apologise. I'm not new to the law. I've been doing it for 30 years. Been teaching, not only practicing but teaching for a long time. It's just I had a bit of difficulty with the IT, and we had to fiddle around with it and stuff like that. And it's been upsetting to me and naturally to yourselves. But anyway, look, it's all sorted out now, and we'll see you next week. Okay, take it easy. All the best to you. See ya. Bye.
So,